to Laws 13013, Legal Professional Conduct, Topic 8, Competence and Care. I'm Stephen Colbran. Practitioner and client expectations concerning competency may differ. While a practitioner may have acted competently, the client nevertheless may feel otherwise, particularly if their objectives were not achieved or the costs exceeded what they were expecting. This topic concerns the issue of competence and care by examining the legal practitioner's ethical duty, contractual and tortious liability, and liability under consumer legislation. The immunity doctrine and how this operates to limit liability for advocates will also be discussed, as will professional indemnity insurance. Finally, we will consider the concepts of confidentiality and privilege. The reading for this week is Isaiah Ross, Ethics in Law, Lawyers' Responsibility and Accountability in Australia, Chapters 10 and 11, and also the Legal Profession Act 2007, Parts 3.4 and 3.5. After studying Module 8, you should be able to explain the grounds upon which a legal practitioner can be held liable for damages arising out of incidents of legal practice, discuss the developments of the law relating to advocates' immunity and assess the current standing of the doctrine, outline the requirements of Part 3.5 of the Legal Profession Act 2007 relating to an indemnity insurance, explain the functions of solicitors' fidelity accounts, or funds rather, and the role of the Law Society in administering these funds, and finally explain whether barristers need to have professional indemnity insurance. Competence and care. Breach of the ethical duty of competence and care is a disciplinary matter. The Australian Solicitors Conduct Rules, June 2011, state in Rule 4 other fundamental ethical duties. A solicitor must act in the best interests of a client in any matter in which the solicitor represents the client. The solicitor must be honest and courteous in all dealings in the course of legal practice. A solicitor must deliver legal services competently, diligently, and as promptly as reasonably possible. A solicitor must avoid any compromise to their integrity and professional independence, and they must comply with these rules and the law generally. The equivalent Queensland Barristers Rules are set out in Rules 37 through to 40. The ethical duties of a solicitor do not end when counsel is retained, however. The duty of care still requires a solicitor to ensure that the client does not suffer foreseeable economic loss and that the client's interest in that litigation is furthered. It is a breach of that duty of care to fail to advise a client that their case is hopeless. This was established in the case of Colavo and Pitzikas, trading as Comino and Pitzikas, 2003, New South Wales Court of Appeal, page 59. Let's then have a look at contractual liability first. When a client offers to employ a solicitor, the solicitor expressly or impliedly undertakes to fulfill certain obligations which are encapsulated in the retainer. Barristers do not have a contractual capacity at common law, except where perhaps a client deals directly with the barrister. So there's no contract generally between the client and the barrister where there's a supervening solicitor. The contract is between the solicitor and the barrister. At common law, solicitors are under a contractual duty to the client to exercise reasonable and competent degrees of skill. In Safe Alley against Sydney Mitchell, 1978, One Weekly Law Reports 849 at page 861, Lord Diplock observed, "No matter what profession it may be, the common law does not impose on those who practice it any liability for damage resulting from errors of judgment, unless the error was such as no reasonably well-informed and competent member of that profession could have made. There are different views on what the relevant standard should be. In your textbook, Isaiah Ross argues that there may be a higher standard because of the reliance the client has placed on special skills of the lawyer. The cases of the Duchess of Argyll and Blueslink, 1972, 2 Lloyd's Reports 173, and Toronto Dominion Australia Limited against Jacques, judgment of Mandy in the Supreme Court of Victoria in 1995, support this view. The scope of representation will depend on the circumstances of the case and the knowledge and skill of the client. Solicitors should advise clients of all the basic remedies available to them, whether instructed to pursue them or otherwise. If a solicitor wishes to limit their advice to certain areas, they should set that out in the retainer. Lawyers frequently hedge their advice with qualifications. For example, they'll use words like likely, probably, or they might use words such as in the circumstances of this case, and then outline situations where it might be different in different circumstances. It would be rare for lawyers to seek to limit their personal liability generally, as really that's not a very good marketing strategy. Barristers can be held liable on equitable grounds for breach of confidence, even if no contract exists between the barrister and the solicitor's client. Lawyers do have a contractual duty to exercise reasonable care and skill, however. This duty has been extended to tort law as well. Lawyers are not liable for errors in judgment in relation to matters of law or discretion. A debate exists as to whether lawyers who hold themselves out as specialists are subject to a higher standard. It is certainly no excuse to argue that they are inexperienced. I think the moral is that you should never take on work beyond your experience without supervision. Such work should be referred to a specialist practitioner if applicable. Can a lawyer be responsible outside the scope of the retainer? In the case of Waymond against Byrne, 1989, 18 New South Wales Law Reports at 642, the New South Wales Court of Appeal held that a lawyer had a duty that went beyond the scope of the retainer and included a duty in tort. In NRMA Limited against Morgan, 1999, New South Wales Supreme Court 409, an expert barrister and expert solicitor were both found negligent in failing to advise on an appeal to the High Court, which had been granted, which could render their proposed advice unlawful. Lawyers can incorporate in Queensland with limited liability and with the right to a public listing. You can see this in the Legal Profession Act 2007 Queensland Part 2.7. One director has to have an unrestricted practicing certificate, and all solicitors responsible under the Legal Profession Act 2007 Queensland are subject to the ethics rules and need to have professional indemnity insurance. Nevertheless, it is a way of limiting liability. Tort liability. Prior to the case of Hedley, Byrne & Co Limited against Heller and Partners Limited, 1964 Appeals Cases 465, actions brought by clients against solicitors were based exclusively in contract. That changed with Hedley Byrne. Hedley Byrne established a concurrent liability in tort. What then is the scope of the duty owed by a solicitor to their client? The starting point is to consider the solicitor's retainer with the client. Here we see an overlap between the contractual relationship between the solicitor and the client and the scope of the duty in tort. If you were retained to do a specific task, then your tortious liability will usually be confined to that specific task. If it falls outside of the retainer, then it will be outside the scope of the duty and no liability in tort would actually arise. Liability can, however, extend beyond the retainer. An example is where the client seeks your advice as to one course of action, but the facts disclose other causes of action. Are you liable to limit your liability to the subject of the retainer? The fact that the client has not specifically asked you to advise on other causes of action does not automatically exclude you from liability. The scope of the duty is going to be limited by the facts of each particular case. Let's have a look at the standard of care. The standard of care is an objective standard based on a reasonable person. The personal characteristics and foibles of the individual defendant are ignored. The standard applied to solicitors is basically the same standard that is applied in respect of contractual obligations, namely, to exercise care and skill or diligence of a reasonably competent legal practitioner under the similar circumstances. There are two questions that generally arise in respect of the standard of care. One concerns the relevance of common practice within the legal profession in determining the relevant standard to be applied. In Rogers and Whittaker, 1992, 175, Commonwealth Law Reports 479, the High Court determined that the standard is not determined solely or even primarily by reference to the practice followed or supported by a responsible body of opinion in the relevant professional trade. The court would be the ultimate arbiter of what the relevant standard was, and common practice would simply be a factor to be taken into account by the court. The other question concerns whether or not a higher standard is going to be applied to practitioners who are deemed to be specialists or who hold themselves out as being specialists in a particular field. The same issue arises with respect to contract. The objective standard takes into account the holding out of special skills. What would a reasonable practitioner with those same skills have done in the circumstances? Let's change tack slightly and look at the liability to third parties. There are limited circumstances in which liability is recognised to third parties standing outside of the contractual relationship and concurrent duty of care between the solicitor and client. In Hill against Van Earp, 1997, 142 CLR 687, the High Court of Australia determined that a duty of care was owed by the solicitor to the disappointed beneficiary under a will. Now, the usual situation in which the duty arises in respect of third parties is where the solicitor has gone beyond their normal role in acting for their client, or alternatively, has acted in such a way as to create an expectation on the part of a third party that the solicitor will take reasonable care in respect of the third party's interests, in addition to the client's interests. So it is usually because of some actions on the part of the solicitor that they assume that additional liability to third parties. So the moral from that is that you need to be careful that you're not creating expectations in relation to people who are not your clients. Moving beyond contract and tort, there is also statutory liability which arises under the Competition and Consumer Act 2010, Commonwealths and equivalent state legislation. Section 18 of the Australian Consumer Law, found in Schedule 2 of the Competition and Consumer Act 2010 Commonwealth, provides that a person must not, in trade or commerce, engage in conduct that is misleading or deceptive, or is likely to mislead or deceive. Therefore, the Australian consumer law enables a person who suffers loss or damage by conduct that contravenes Section 18 to recover the loss or damage by action against the person responsible. Such remedies are theoretically possible against lawyers, although there's been no definitive case law examples so far. We'll now examine the topic of advocate's immunity. In an edition of the Law Report, Damien Carrick commented, "Here's a riddle for you. What do architects, civil engineers, dentists, doctors, electrical contractors, financial advisors, pilots and teachers all have in common? Answer: if they're negligent, you can sue them. But what about lawyers? Should you be able to sue a lawyer if he or she stuffs up your legal case? It only seems fair. After all, a lot of lawyers make their money hauling other people before the courts. Surely what's good for the goose is good for the gander." But the answer apparently is no. There is an advocate's immunity. The traditional English view, according to the case of Rondell and Worsley, 1969, 1 Appeals Cases 191, is that public policy requires that barristers do not owe a duty of care to clients of solicitors who engage them. A barrister is immune from any action for professional negligence in respect of acts or omissions during the trial of criminal proceedings against his lay client. In the United States, while mere errors of judgment did not found liability, there is no general exclusion of liability for error. So what are the arguments in favour of this immunity? If barristers could be sued, they would be so concerned for their clients' rights that they would not observe their duty to the court. The cab rank rule means barristers have to accept clients as they come. If there was a fear of negligence, that would make barristers overcautious and very prolix in the manner in which they argue their cases. Barristers should be treated like the judge, jurors and witnesses, etc., all of whom are immune from litigation. Allowing negligence cases would result in relitigation of cases and collateral attacks on final judgments, resulting in the undermining of public confidence in the administration of justice. And finally, the assumption that barristers may not sue for their fees. What are the arguments against the immunity? The barrister's duty to the court will remain paramount over claims of negligence. There is an absence of empirical evidence of dire consequences flowing from removal of the immunity. Collateral attacks are no reflection on the administration of justice, merely that the barrister had not properly conducted the case. And it could be argued that failure to provide a remedy may do more harm to public confidence in the administration of justice. The House of Lords in the case of Hall and Simmons, 2000, 3 All England Reports 673, removed the immunity of suit for barristers and solicitor advocates in the United Kingdom. In Australia, the High Court in the case of Gianelli and Wraith, 1988, 165 CLR 543, confirmed the common law immunity of barristers and solicitor advocates on the basis of work done in court and work outside of the court that was intimately connected with the work done in court. The court was concerned with two main policy issues. Firstly, the overriding duty of the advocate to the court. Potential for conflict exists between the advocate's duty to the court and the duty to the client. The advocate should feel confident that the overriding duty to the court should not be undermined by fear of being exposed to liability and litigation. Secondly, the undesirability of exposing court decisions to collateral attack by negligence actions against advocates. The High Court was fearful that confidence in the judicial system would be undermined where cases were relitigated years after they had been decided because an accident in negligence had succeeded against an advocate in a particular action. This would have ramifications on the precedent value of cases and could undermine the court system, they thought. In the case of Deorta Kenvale against the Victorian Legal Aid, 2005, High Court 12, the High Court affirmed the continuation of the barrister's immunity in Australia. So you can see that the position in the United Kingdom and Australia now differ. Let's move on now to professional indemnity insurance and the Fidelity Fund. Firstly, what is professional indemnity insurance? It's a form of insurance that indemnifies the insured against the consequences of a breach of professional duty and particularly professional negligence. A professional indemnity insurance policy may provide indemnity against all losses that the insured sustained resulting from professional errors or omissions in the conduct of its business. So was held in the case of Simon Wanderer Proprietary Limited and Swain, 1960, 2 Lloyd's Reports 111. Or it may provide protection only against claims arising from professional negligence, strictly so called. That's the case of Walton against National Employers Mutual General Insurance Association Limited, 1973, 2 New South Wales Law Reports 73. Compulsory professional indemnity insurance developed over the past 30 years in response primarily to consumerism. You should take the time and study the provisions of Part 3.5 of the Legal Profession Act 2007, Queensland. The Legal Practitioners Fidelity Guarantee Fund is established under the Legal Profession Act to provide compensation to people who may suffer loss in the event of dishonest failure to account or dishonest default by a solicitor, typically in relation to trust accounts. This Fidelity Fund is administered by the Law Society. This concludes Topic 8, Competence and Care. Next week we will be looking at Topic 9, Confidentiality.